Is the third time a charm for the Supreme Court? Well, we're about to find out. We just submitted our petition for a writ of certiorari to SCOTUS in our case, Antonyuk v. James. This case started our challenge to New York's attempt to ban concealed carry by listing everywhere they possibly could as a sensitive place. But now is kind of a referendum on lower courts standing in defiance of the High Court's rulings. All of that and more coming up. I'm Phil, and you're watching Law and Ammo. But before we get into the video, I want to take a second and let you know about GOA's annual convention. Goals. The Gun Owners Advocacy and Leadership Summit is set to be held August 9th through 10th of this year in Knoxville, Tennessee. Come out and visit with some of your favorite manufacturers, participate in activism training, and hear from the top voices in the Second Amendment community. And the best part is that it's free for GOA members. So sign up using the link in the description. Now back to the video. Our case, Antonyuk v. James, has quite the history at this point and has gone by many different names. The case started in 2022 in the wake of the Bruen decision, which, for those new to this channel, was a landmark decision by the Supreme Court that said the Second Amendment extends outside the home and therefore you have a right to carry a firearm protected by the Constitution. And of course, New York, one of the most anti-gun states in the country, and the defendant in the Bruen case was not pleased with this outcome. So in response, New York complied with the decision in Bruen, allowing New Yorkers to obtain carry permits, but also passed a massive law called the Concealed Carry Improvement Act, or CCIA. The law became the foundation for our lawsuit in Antonyuk. It basically took all sorts of locations throughout the state and made it illegal to carry a firearm there where it had been previously legal, citing those areas as sensitive places. When asked if there was anywhere that gun owners could carry in New York City, Governor Hochul replied, "Maybe some streets."
It sounds like you're shutting off all of the public places.
I can't shut off all places.
So what would be left?
Probably some streets.
Hochul and the supermajority of anti-gun politicians in the New York State Legislature passed what was a de facto ban on concealed carry statewide. In addition, it also put a good moral character requirement on licensing, effectively denying New Yorkers carry permits for having parking tickets. And worst of all was the CCIA's so-called vampire clause, where if signage was not explicitly posted allowing firearms on private property, state law assumed that firearms were banned. This would have made the entire state into a massive web of gun-free zones. We at GOA knew this couldn't stand, so we sued them. And at first, we won at the district level, halting the rule. The Second Circuit overturned. We, of course, then appealed to the Supreme Court, but were denied because the case was in motion. The Supreme Court doesn't like to interfere with the dockets of lower courts unless it's really needed. So we fought with the Second Circuit for months, with that court finally deciding that they were allowed to, in practice, completely ignore the decision in Bruen, even citing a law review article titled "The Dead Hand of a Silent Past: Bruen, Gun Rights, and the Shackles of History." In this law review article, the argument is made that lower courts should ignore or narrow Supreme Court precedent from below. The argument of narrowing from below translates to ignoring the precedent as much as possible by lower courts. This is in effect what the Second Circuit did in our case. The author of that article, Jacob Charles, is an affiliate scholar of the Regional Gun Violence Research Consortium at the Rockefeller Institute of Government. And so it sounds like he's probably not the biggest fan of the Second Amendment. Of course, the Second Circuit narrowed from below, decided against us, and upholding New York's Concealed Carry Improvement Act. So with the case decided and the docket uninhibited by further proceedings, we appealed to the Supreme Court. Our case sat on the Supreme Court's docket for a bit, before getting granted, vacated, and remanded in light of the Rahimi case. When the Supreme Court GVRs a case, it means that they're asking the lower courts to reconsider their decision based on another ruling. In this case, that was the ruling from U.S. v. Rahimi. So what was it about the Rahimi case that made the Supreme Court tell the Second Circuit to reconsider? It's likely it's this paragraph. Finally, the court rejects the government's contention that Rahimi may be disarmed simply because he is not responsible. The court used this term in Heller and Bruin to describe the class of citizens who undoubtedly enjoy the Second Amendment right. Those decisions, however, did not define the term and said nothing about the status of citizens who were not responsible. This so-called responsible term, which is embodied in New York's good moral character standard, has been used by judges there to rule that people are dangerous, not merely because of criminal conduct, but because of things like their traffic record or other non-criminal acts. So in Rahimi, the Biden Department of Justice brought this case before the Supreme Court to challenge the Bruin decision and establish a responsible standard for denying guns to American citizens. The Biden administration found the worst person they could in Zachary Rahimi and attempted to get the Supreme Court to argue that he could be disarmed simply for not being responsible. But thanks to this line in Rahimi, those words from the Supreme Court effectively run counter to what New York wanted out of their Concealed Carry Improvement Act. That's why our case was granted, vacated, and remanded in light of that decision. But where are we today? Well, the Second Circuit decided that the Rahimi decision didn't matter, and again sided with New York State in defending the CCIA. In fact, they issued a near identical decision claiming that Rahimi had little direct bearing on our conclusions. Yet they upheld New York's good moral character requirement directly at odds from the paragraph that we just showed you from the Rahimi decision. So we've appealed to the Supreme Court with a writ of certiorari, which is essentially a plea for the court to hear our case. We're asking the Supreme Court to answer two questions. First, whether the proper historical time period for ascertaining the Second Amendment's original meaning as applied to the states in 1791 rather than 1868. And two, whether the people must convince government officials of their good moral character before exercising their Second Amendment right to bear arms. The Supreme Court needs to take up this case because it has far-reaching consequences that could affect the entire country if ignored. If SCOTUS doesn't take up Antonyuk, it sends a signal to other anti-gun states that they're free to ignore Bruin and other Supreme Court rulings that they just don't like. That's a very dangerous precedent to set. Other anti-gun states like California and Maryland have both passed legislation similar to New York's CCIA. If these laws that directly stand in defiance of the Bruin decision are allowed to stand, more states will follow suit and pass their own CCIA-like legislation. Here's hoping that doesn't happen and that the Supreme Court takes up Antonyuk. I'm Phil, you're watching Law and Ammo, thanks for watching.